Good afternoon, ladies and gentlemen in the room, online as well. Thank you for rejoining us in this afternoon session of the first day of our closing conference on the Freedom of Expression project. We had very interesting morning discussions on the most noteworthy examples of successful or at least some proportional success of our advocacy on free speech cases. We had an extremely important and timely discussion on jurisdictions faced with severe SLAPS problems, and there we saw how we can have still successes, procedural, substantive, or at least organizational as NGOs, even in challenging circumstances, in the face of systemic SLAPS problems. And now we begin our afternoon discussions with perhaps some of the most challenging jurisdictions for the whole convention system, but also in relation to free speech matters. What links this discussion today is that the jurisdictions concerned present, of course, like the previous ones today, by free speech problems, but these problems are not isolated. The free speech thematic is not one major thematic in the jurisdiction. It is one of the many. It inscribes into a general adverse environment for democracy and the rule of law in these jurisdictions, and like that it becomes a symbol of a symptom rather of generally ailing democracies. And it is important to keep that aspect in mind, because the discourse then, the discussion becomes a bit different. We are talking about achievements, we are talking about good practices and how to transpose them to other jurisdictions, but is it enough if these good practices we come up with as a result of our 2-year work on this project can be transposed in those jurisdictions and can miraculously better the situation in those jurisdictions? We are here to discuss these matters with very close friends and colleagues from close collaborators of the EIN in general, but also in the context of this free speech project. We will begin with Turkey, the situation in Turkey, which will be presented together with the great work our collaborators did for this free speech project by İdil Özcan, lawyer and project officer, Truth, Justice, Memory Center, Hafize Merkezi in Turkey. İdil studied law and sociology in Turkey and earned her master's degree in law from the London School of Economics. After working as a legal counsel, she joined the legal studies team at the Memory Center in June 2022. Her work focuses on two main areas: combating impunity for grave human rights violations, such as enforced disappearances and use of lethal force involving security forces, and the repression and harassment faced by rights defenders in Turkey. She contributes to the Memory Center's advocacy efforts through Rule 9.2 submissions and other communications to international mechanisms. But it would be an omission, Idil, not to acknowledge also our other collaborator in this effort, among many, MLSA, the students, the Law Students Association. Media Law Studies Association, yes, MLSA. Batika Nerkots is with us. Thank you very much, because you collaborated also on some submissions, but the association also has done a lot of groundbreaking, important work on statistics, also on gathering of evidence at national level, which has also contributed to the international level to record the magnitude of the problem. I give the floor without further ado to Idil to describe a complex situation in Turkey.
Thank you. Thank you very much for the kind invitation, and I am also very happy to be here, but unfortunately to discuss a not so happy story when it comes to implementation. So I will be talking about Turkey and how it oscillates between defiance and engagement, and I will skip, for time constraints, I will skip part of the presentation, like kind of giving you the overview of the situation in Turkey, because Dunya has also mentioned it, and I think some of you might be familiar. And I will try to be brief, but we'll see. So as you know, we've been witnessing a democratic backsliding in Turkey for some time now, which has worsened after 2016. And we still continue to see a crackdown against dissent across the political spectrum, against protesters, activists, rights defenders, journalists, lawyers, etc. But this is nothing new in Turkey, and freedom of expression violations are rather a long-standing systematic problem. And here you can see that some of these case groups pending before the Committee of Ministers are there since the early 2000s. And some groups have been closed after amendments were made, which were, in fact, some of which were prompted by the implementation process itself. But similarly, problematic provisions took their place over time, so we're still in a difficult situation. And when you look at these leading cases against Turkey today, you can see the kind of laws that are being used to target dissent, and I will, yeah. And these are statistics that Julieta just mentioned from the Media and Law Studies Association's trial monitoring data. And here you can see that terrorist propaganda for a terrorist organization or being a member of a terrorist organization are common charges which constitute almost 25-26% of freedom of expression cases in Turkey. And of course, needless to say, all of these cases are brought under bogus charges with evidence such as social media posts or professional activities of lawyers, meetings, etc. So, we see that it's dissent that's being criminalized here. So I thought the agenda rightly identified some stumbling blocks, and I just wanted to mention how the laws in Turkey and their application coincided with these blocks, and then I'll give you my 2 cents on what I think might be a way forward. So when it comes to restrictive laws, I think Turkey is an interesting case, because so much of Turkish legislation was amended in the early 2000s as part of the EU accession process, and we saw these amendments as a response to criticism, and over the years we saw more amendments being made in response to international criticism, such as the addition of this sentence, expressions of thought for the purpose of criticism shall not constitute a crime, across different articles, and other such provisions you can find across legislation. But of course these amendments did not have a positive effect because it is the judiciary that continues to apply laws in a very restrictive manner. As was mentioned earlier in the panels, it's not the laws that fails, but it's rather the practice. But that said, we also see that we don't have strong enough laws, so we have vague wordings of laws that are constantly abused in arbitrary prosecutions. We have a very broad definition of terrorism that makes it very easy to deem anyone a terrorist. And what's also important to mention here, I think, is that some of these laws do not even fall within the scope of the Committee of Ministers review. So, if we're talking about the implementation process, we see that some dormant articles that are not were commonly used in the 1990s, for example, but which have fallen out of use, are revived. So instead of heavily criticized articles, we see that these older articles are used more extensively. So for instance, we have Article 6, Paragraph 1 of the anti-terrorism law on disclosing the identities of officials on counter-terrorism duties or identifying them as targets. As an example, And this was mostly used, again, as I said, in the 1990s, and then it's now revived to target journalists and lawyers and for their, for their work. And similar to the slap cases actually mentioned again earlier, we see that this is used to target, to protect allegedly members of the judiciary, so prosecutors, judges, and even politicians as officials on, so to speak, counterterrorism duties. And we also see ongoing discussions and risks around new laws that restrict freedom of expression, such as an agents of influence law or a new anti-LGBTI draft law which seeks to criminalize expressions of gender identity. So you can see all sorts of different parallels that we discussed also earlier in the morning. And I think one of the difficulties in the implementation process from the Turkish perspective is also this ever-changing legislative and judicial agenda that introduces new laws, new debates, constantly creating new risks. So for us, we try to engage in the implementation process via the cases pending before the Committee of Ministers, but we have all this, plethora of new laws, new risks that we also have to deal with. And secondly, Turkey has a very significant problem of weak institutions coupled with the lack of political and judicial will. We cannot speak of an independent and impartial judiciary in Turkey. And last year we also observed how lower courts can act in complete defiance of the Constitutional Court. In the case of Can Atalay, who is a lawyer and rights defender, still in prison today. And the Constitutional Court ruled twice, actually, that his ongoing detention as a member of parliament, after he was elected, was a violation of his right to liberty. But both the lower assize court and the Court of Cassation completely ignored these judgments and ruled against his release. So this is, I think, one example, only one example of how political will, the lack of it, is reinforced through these dysfunctioning judicial mechanisms that provide no oversight. And as for reprisals, we see a lot of judicial harassment in Turkey, and I'm just unable to mention all the significant cases. But we see, arrests, detentions, travel bans, house arrests, investigations, prosecutions, you name it. We see it as a means to suppress human rights advocacy constantly, and as well as other restrictions. And lately we saw the dispersal of peaceful assemblies in a very violent way in March 2025. So these are just some basic examples of what we have in Turkey today. So against this background, how does Turkey approach implementation? I believe what characterizes it is Turkey's defiance, but alongside a strong engagement with the system. And what I mean by this is this. So Turkey is a persistent violator of international human rights standards. It does not comply with ECtHR judgments, which was already confirmed by the court itself in infringement proceedings. But at the same time, Turkey is incredibly engaged with the Council of Europe mechanism. It holds regular meetings with representatives, it submits its action plans on time, it provides information and statistics to the committee when it's requested, but it does so in a very misleading way, or it responds to our Rule 9 submissions, but again, only to call it speculative information. And as I mentioned earlier, there are sometimes amendments to laws, but these are very cosmetic changes that bring no change, no positive impact. And just like to give you an example, last year the Constitutional Court annulled an article on committing a crime on behalf of a terrorist organization without being a member to it. It was a vague wording that was extensively used, and it was annulled, but the parliament overrided this by introducing an amendment which was almost exactly the same wording. So yeah, even you can say that it's even harsher to an extent. So we see a lot of ritualism. We see a lot of selective compliance. But as I said, like beyond this, there's still engagement, which actually opens up a very valuable space for us, an opportunity for us to engage in somewhat a dialogue with the government, which is indirect but still present at the international level, but which is absent completely at the domestic level. So we really value the Rule 9 submissions and the processes at the Committee of Ministers, because that also enables us, like, not just for us to get our story across, but we also are able to obtain a lot of information and statistics when we request it through the committee. So that's also very helpful for us. So the question is then, how can we overcome all these blocks and ensure implementation? I think there's no simple answer to this, but I will try to give you a simple answer. I think it's to raise the stakes for non-compliance. I think Turkey's maintained engagement with the system shows that it holds a very transactional view of compliance. It views it as part of a very as an important part of a cost-benefit analysis in its diplomatic economic relations. And as a result, it does not, and I don't think it will, abide by its obligations unless there is real pushback. And I want to give the Kavala case as an example at this point. I won't go into detail again on the case, but Osman Kavala is a rights defender who has been in prison since 2017 under bogus charges. And Turkey first did not comply with a violation judgment, which then led to infringement proceedings, which then led to a violation finding of Article 46. And then Turkey still convicted Kavala to an aggravated life sentence and did not release him. And in the end, not much happened. Like, Turkey did not face a very significant backlash. And we see that the committee still reviews the Kavala case regularly and calls for his release, holds meetings, etc. But it has been more than 5 years since the initial violation judgment and more than 3 years since the infringement proceedings judgment, and we see, unfortunately, we don't see much impact. And the same can be said for Selahattin Demirtas as well, who remains in prison since 2016, again, despite repeated calls from the Committee of Ministers. So from our perspective, what I see is that the Council of Europe is kind of walking on a tightrope in its relations with Turkey. So we have previously heard some concerns that if they push Turkey to a farther point, if they exert too much pressure, Turkey will end up in a similar situation as Russia. That's kind of the fear that has been voiced. So to keep Turkey within the system, they're trying not to offend it too much. But I find it, rather unlikely that Turkey will do so because as this was, and I quote Julieta on this, Turkey is a very proud member of the Council of Europe, and it's far more engaged with the West. It's far more dependent on the West. So that's why it wants to maintain these strong relations, and that's why we need stronger reactions, actually, to Turkey as well. So what can we do as civil society? And then I finish. And this is also a message to funding organizations as well. This was already mentioned earlier. I think it is to facilitate face-to-face meetings and interactions between civil society and international actors, international organizations. Last year, thanks to the support of the EIN, we, together with MLSA, had a civil society briefing in Strasbourg, and it was immensely, our experience was immensely positive. And I think we saw the direct impact also in the wording of the Committee of Ministers' decision, which directly referred to information submitted by civil society. So, we make submissions, but we never, or we rarely see such a direct translation of impact into the decisions. And the second thing I want to mention is, again, building networks, building solidarity. What I learned today, and some of these things I heard today really resonated with me in terms of, what we go through. And we definitely can share tactics, Of course, some things work in certain jurisdictions and in others they don't. But I think, when authoritarian practices are just sweeping the globe, we need more of solidarity. But again, I just want to finish by saying that no matter how much, how hard we work, it is again, the Council of Europe, the Committee of Ministers, it's the institutions that have to do the work, that have to step up, because, that also helps us, at the domestic level, giving us leverage, giving us a certain degree of protection, and hopefully, there will be some change. But, thank you.
Thank you very much, Idil. I have said it on many occasions before. I tip my hat to the great work of our colleagues in Türkiye. You continue carrying the torch of the convention under very difficult circumstances. We do our best to support you at international level, but the type of advocacy we do is a type of a luxury advocacy compared to what you're doing in Türkiye. So we thank you for your engagement and your perseverance under some of the most difficult circumstances, the same difficult circumstances that other members of civil society in jurisdictions that will follow will talk about. Out of the very many, you portrayed very aptly a very dire situation in 10 minutes. You were very comprehensive. I retain a couple of elements. The first one is that Türkiye is still interacting with the international community. This is very important. Of course, this interaction is super problematic. It is manipulated. It is weaponized. But it still we have not lost Türkiye in the way that Russia was lost, or perhaps we will see if other jurisdictions are lost. Of course, I don't want by this to downplay or undermine how dire the situation is. We cannot forget, and we will keep mentioning, that Kavala is now the most important example of a case setting a ticking bomb at the foundation, the very foundation of the convention system. It is an unprecedented, unparalleled situation that needs to be resolved yesterday. We need a completely different type of political will to tackle this problem, because this problem now has surpassed everything we know so far about resistance to the court's jurisprudence, and it starts putting into question the very foundations of our implementation mechanism. I think I will, and a second issue I wanted to raise was the issue of weak institutions. Out of the very many problems that plague the Turkish jurisdiction and have an impact on the free speech situation, is the weakness of institutions and the situation of the judiciary. A difference I find with our previous discussions is that you can have judges who ignore laws or use or still apply laws that are outdated, but perhaps they do it out of ignorance sometimes. Here I think it's much more well known that free speech is problematic, and still judges, and this is a sign of a captured judiciary also, they keep applying those laws. So we're talking about a different kind of problem there that needs to be tackled. Moving on from Türkiye to, in my opinion, an even more dire jurisdiction. Unfortunately, we will pass on to see the situation in Azerbaijan. We have with us for the second time today Ramut Ermezaide, our vice chair at EIN. I think your CV was presented as a kind reminder. You're a senior legal consultant and implementation lead at the European Human Rights Advocacy Center, ERAC, our very close friends and collaborators, based in Middlesex University, a great scholar but a practitioner also for over 15 years, with a PhD in law from Middlesex University, where you researched exactly compliance with ECtHR judgments in states on the spectrum of democratization, with particular focus on the South Caucasus states. You will present to us the situation in Azerbaijan, and perhaps part of the problem and the reason we have you speak about these cases links with the type of problems that our colleagues in Azerbaijan are faced with, which exactly demonstrate the magnitude of the problem. I will say no more, and I will pass the floor to you, Ramut.
Thank you, Julieta. I'm sorry you have to listen to me a second time today. I think it's quite symbolic to be on a panel on the best practices and successes, and also to be on a panel on perhaps the worst implementer in the Council of Europe. It is difficult to do justice in 10 minutes on the situation in Azerbaijan, but I'll do my best. And I'll take note of the time. In my presentation, I would like to speak primarily about three things. And I know it is difficult to keep that tension on a session that follows right after the lunch break, but I think one exercise that I have for all of us is to think what can be done and should be done with a member state that clearly refuses to comply. It's not about the challenges, the difficulties around, or it's not about slow implementation, it's not about partial implementation, it's really about the systemic resistance to comply. That's why I added, in the title, I added the word resistance. I know that quite a few years ago, this was too much of a word in the Council of Europe, but I think today, and I think as Dunja Mijatovic has rightly said, we cannot buy this anymore, that this is a part of the path towards the democratization. So I would like to raise three things. Firstly, to say that the situation in Azerbaijan is not about implementation of individual judgments, and that there are different challenges depending on the substantive matters addressed in those judgments. We are talking about the systemic resistance. We're talking about the state policy to not comply with the judgment, because this is something that goes against the domestic, political, personal interests of the ruling power. I would also like to touch upon the situation of the civil society, which it finds itself in, and this is, I feel comfortable to say, the only domestic actor that tries to drive the implementation process. When the state authorities that carry the voluntarily accepted obligation to comply do not do that. And I'll also talk about the civil society's price that they pay for their courageous work. And finally, I would also like to speak about what do we do about it. It does require a very, very different approach. There can't be any more business as usual. I know we've been saying that for a while about Azerbaijan, and we still find ourselves in the business as usual, and I will try to present some recommendations on that. And I'm also sorry to say that we do not have our Azerbaijani colleagues here, and I think a part of that is an indication of the situation they find themselves in, where today they're either behind the bars or they are working from exile, and that's something that Azerbaijan has reached a new and even further new low in its in the current situation. So very briefly, I won't go into many details in this slide, but here the main message is to say, so there I've listed the types of Article 10 cases that Azerbaijan has, but my main message here is that any judgment, pretty much any judgment that you take against Azerbaijan, it has to do with the repression of the attempts of using free speech, be it a direct Article 10 situation, or be it an Article 2 or Article 3 types of cases against journalists and other critics where they're being attacked and even lose their life, be it about Article 18, and the detention cases where many Azerbaijani journalists and human rights defenders and anyone who exercises their free speech in talking about the situation in Azerbaijan, that's what the vast majority of the judgments against Azerbaijan deal with. So it's not really about the individual cases, it's about all the judgments against Azerbaijan that we need to speak about, and that these judgments mainly reflect a very grim reality for the media and wider human rights situation today, rather than help the authorities identify where the difficulties or gaps are that need to be addressed. I will move to the next slide here to say that, we heard today about how Rule 9 submissions and the process before the committee is seen as a very effective, perhaps the most effective way for the civil society to engage with the implementation. And what I would like to say that with regard to Azerbaijan, this is the only way for the civil society to engage. There is no dialogue whatsoever with the authorities on the domestic level. And although I do agree the situation in Turkey, for example, is very dire, but the civil society is still able to operate, is still able to engage to some extent. And you've said, Idil, how the authorities are incredibly engaged with the process. Whereas with regard to Azerbaijan, it's really the Rule 9 submissions and any other interactions with the Committee of Ministers and other Council of Europe bodies are really the only ways for them to raise implementation issues. So that's something, an important thing to mention. And although the authorities do engage to some extent, it's rather procedural, kind of a process-based type of interaction where and this has reduced significantly in the past year, where what I mean here that the substantive information that they report on as progress is not really something of sufficient, is not sufficient to be recognized as real progress. I also want to mention the significance of collective civil society initiatives such as this project that enables the Azerbaijani colleagues to initiate this momentum for implementation and engage the authorities, because I really think that if not for this kind of support and for the Azerbaijani colleagues' ability to file Rule 9 submissions, we would barely hear from the Azerbaijani authorities. And then my next slide, thank you, is elaborating a bit more about how important it is what the Council of Europe does towards Azerbaijan, because this is really the only way, kind of the only tool the civil society and that we all have to address the situation in Azerbaijan. And where the Council of Europe, my main message here would be that this huge challenge that the Council of Europe has in its European family today, a country where there is no more independent media or the civil society. It used to be still a couple of years ago. Now they are either in detention or trying to establish themselves in exile. And also we have a state where, in fact, it does take active steps to silence those people, to imprison them or force them out of the country. Just last week, we had a group of our colleagues, journalists and human rights defenders, who were sentenced to 7 to 9 years in prison. And that the country that clearly fails and refuses to comply with the European Court judgments, and furthermore, it significantly, increasingly disengages with the Council of Europe processes. And I'll mention a couple examples of that in a bit. So really, what do we do with a country like that, which clearly shows that it's a well-evidenced state policy to not comply, to not engage, and this clearly cannot be business as usual. One challenge to that, and perhaps one thing that led to Azerbaijan where it is now, and it allows itself to do what it does, is the absence of clear consequences of this non-compliance from the side of the Council of Europe. So as some of you may know, Azerbaijan has had a similar crackdown in 2014, and a number of very strong imported judgments came out from the European Court, which is now known as the Mamadli Group, which deals with Article 18 cases, where basically court has established that the government has been putting those people in prison for their political purposes, ulterior purposes. A second group deals with restrictive NGO legislation, a big group of cases. And these cases are significant because the crackdown, both the current one and the one from 10 years ago, basically targets, attacks NGOs for their failures in relation to their restrictive NGO legislation. Basically, the Russian foreign agents law from the back door. And these two, what we have so far, for example, the NGO group of cases is still under the standard supervision. The Mamadli group, what we get so far is the serious concerns from the Committee of Ministers, but we haven't seen more than that. And so there clearly is a direct link between that failure to respond to the government's failure to implement those groups of cases and the current crackdown, and it really enables and allows the authorities to continue its business as usual because they don't pay the price. And one important thing that I wanted to mention is also that Azerbaijan is increasingly disengaging, differently from Turkey, for example, disengaging with the Council of Europe, various processes, and that's not only the Committee of Ministers and the supervision process, but it also has to do with ignoring, say, Venice Commission recommendations. It's about the CPT and their complete closure from their process. It's the refusal to allow election monitors into the country. So it's really, you pick which area of cooperation that the Council of Europe offers. And if we can move to my last slide. So what is the way forward? The situation in which Azerbaijan is clearly has zero prospect of turning around in the current context, in the current climate. And it's also very clear that Azerbaijan does not share the values of the Council of Europe. And yet it still enjoys a full membership. I know many of us believe, including the Azerbaijani colleagues, that they cannot lose the Council of Europe because that's their only hope. That's the only hope for recognition of violations, the recognition of injustice. But at the same time, Azerbaijan is not going to implement the judgments, including given the most recent speech by the President Aliyev, where he has said that Azerbaijan will no longer implement judgments unless the voting rights, the credentials at the base are renewed. So we clearly need to think about any remaining tools and ways to address this. And so there clearly needs to be a significant shift in the Council of Europe approach if Azerbaijan is to stay in the European family. And I think what is needed is a consistent, clear messages from all Council of Europe bodies towards Azerbaijan. So today, Azerbaijan has heard from the PACE and the suspension of the credentials, and it has angered the government enormously. From the Committee of Ministers, I'm not sure if they hear enough about the possible consequences of the non-compliance. I have mentioned the two groups of cases, which I won't go into details now, which clearly serves as a very strong basis for the Committee of Ministers to take on Azerbaijan on its failures in a much, much stronger and serious ways. And Idil has also spoken about the tools, including infringement proceedings, about the clear failure and refusal to implement, really refusal. It's not the failure anymore, which is a much broader phrase, but really about the refusal to implement. And my last message would be also about the urgent need to support the remaining civil society. And by saying remaining civil society, we're really talking about a handful of individuals who are still there to continue their work, to drive this process further. They need the Council of Europe, but as I see things today, the Council of Europe also needs them to be able to to continue engaging on the situation in Azerbaijan. And my very last point is to say that the time is really now. There won't be any other time to act. And I think if there is one thing we've learned from the situation of Russia, it is that acting too late amounts to not acting at all. And we have to act now and soon, lest there be no civil society and journalism in Azerbaijan anymore. Thank you.
It is a very dire situation. I think from what we have discussed so far, it is the most dire situation, actually, with very difficult questions raised and no answers, literally no answers. The absence of dialogue whatsoever with the authorities is a big problem. We know what it is like to deal with recalcitrant interlocutors, but the whole situation goes to a whole different level when the interaction is no longer there. The issue of how to deal with such a jurisdiction lies at the heart of all discussions, and there I will also say, and I will add to what you said, that there's this dual approach. What do we do? Do we allow a member state that is so problematic to drag down collectively the standards for the whole Council of Europe spectrum? Do we accept the risk that perhaps we lose another country with whatever that entails for the system, for the remaining human rights defenders, but also the whole population? It is very, very regretful and very worrisome that only a handful of human rights defenders and journalists remain active for all the reasons that you explained, Ramute. It is unimaginable as a situation, but then if we lose another country, if we lose Azerbaijan, then this will affect the whole population. Then this lack of oversight into what is happening in the country will affect much more. It will have much more wider consequences other than for those colleagues of ours. Politicization of implementation, very big discussion. How this is manipulated. How instead of the system generating response from the authorities are using the recalcitrant stance to generate, to reverse the actions of the Council of Europe. It goes beyond my understanding. It goes into the sphere of surreal, only that it is very real and very pragmatic and very dire. Very importantly, I need to say, because we still managed to do great work on this project, on Azerbaijani cases, with institutions, media journalists, human rights defenders, concerning human rights defenders like the Khadija Ismailova cases. So great work done. With impact still, as we consider it, at Strasbourg level. So this generated impact in the sense of the arguments being picked up by the committee of ministers, like in the Turkish cases, and the committee passing strong messages, but then there are no recipients for those messages. Unlike other jurisdictions, when this impact can still generate some change, here we're talking about a completely different situation, and the answers must be put at a completely different level as well, and we will of course continue discussing on those matters, but a very dire situation indeed, and it is regretful that as a tangible result thereof we could not have an Azerbaijani colleague with us today, but you did an excellent job, Ramute, in explaining the situation to us, and I thank you very much for this. Moving on to the next jurisdiction, we will now pass to a jurisdiction that is very close again to the hearts of all of us, because for very many years has been on the path towards the European family, the path of establishment of greater democratic rules, the rule of law. Resistance was in place, but progress was also in place for a very long time. It was looking hopeful. I'm talking about Georgia, of course, and which represents an example of how whatever we discuss, we need to be very careful of what we discuss, how we convey the messages, and how mindful we need to be of circumstances and developments we cannot foresee with absolute certainty, because what is happening now is the very swift reversal of this situation under the weight of many circumstances, of course, and developments. But what is happening now is that slowly but surely, and even not so slowly, Europe is losing Georgia. Europe is losing Georgia, and on all fronts, in terms of upholding of democratic rules and the rule of law, with repercussions everywhere, very dire consequences, very fast. We are talking about a rollback, a very swift rollback on all fronts, a complete change of direction. And the real question, everyone is shocked by this, and the civil society colleagues are, of course, at the front line of trying to combat this situation with increasing risk, rapidly increasing risks for you. But this has a very concrete, indeed, impact on the free speech situation, because the limitations to free speech, other than being an important problem for Georgia, it is also weaponized in this. It inscribes into the overall context of rollback of liberties, and it becomes a weapon in the hands of the authorities. I need to say that this rapid deterioration of the situation is the reason why Georgia was the only jurisdiction in respect of which, although we had a partnership with Gaila, we did not manage to develop project activities. It was the only country, and this was because civil society partners had to redirect all resources to the combat of this rollback. I will say no more. I will leave the floor to explain all that to Tamás Kirtava, project coordinator from the Georgian Young Lawyers Association, our very much beloved Gaila. Tamás is a Georgian lawyer and human rights defender, holding the position of project coordinator at the Georgian Young Lawyers Association. His current work focuses on the rights to freedom of assembly and expression, equality, and the protection of vulnerable communities, among other key priorities. At Gaila, Tamás, you have been actively involved in monitoring public assemblies, tracking legal developments, documenting violations and the broader human rights situation in Georgia. Among your notable contributions, you recently co-authored an in-depth report documenting the ongoing human rights crisis in Georgia, as well as a study evaluating Georgian judicial proceedings in light of the European Court of Human Rights case law. Tamás, the floor is yours.
Thank you for this introduction. First of all, that's true. Georgia is facing a very rapid decline and escalating crackdown on human rights and civil society. And among many other human rights, freedom of expression is at the heart of this crackdown. I think it's important for us to think how this repression started. It didn't happen overnight, so how did we arrive at this point? First of all, I think we should mention that with regard to Georgia, the decisions solely invoking Article 10 are not many. However, this article has often been evaluated by the court in light of Article 11, like Peradze case, which is part of the Makarashvili case, which has recently been transferred to enhanced supervision due to the massive violations of freedom of assembly and fair trial, which is a group of cases concerned. And I think it's also important to mention Sinsabadze group of cases, which concern the violation of Article 2 and Article 3 in both substantive and procedural aspects of these rights because of these recent cases of systemic torture that we've been witnessing in Georgia. It is important to, like I said, go back to the beginnings of this crackdown. The civil society has been target for Georgia for quite some time, but the turning point was 2023 when the government, through its satellite parties introduced the foreign agents law, which with its structure and with its spirit was very similar to the Russian law that discussed in a eco-defense case. And of course, because of this similarity, the Georgian people kind of named this a Russian law, and there were mass protests against this law, so the government has to repeal it because of the public pressure. However, a year later, Georgian Dream reintroduced it, and this time they were ready for a much wider scale of brutality, because despite the uproar, despite the massive protests, they passed the law with violent dispersals of these mass protests. And since then, I think the situation has been escalating rapidly. Another turning point, another unfortunate milestone on this path was November 29, when the Prime Minister of Georgia made statements announcing the halt on EU negotiations, which again caused a massive protest. And this was a point when the state started using mass torture against demonstrators. They were arbitrarily detained, they were severely beaten, including children, including people with disabilities, gender-based forms of gender-based violence have been weaponized against women. And since then, there have been a rapid abuse of legislative powers with amendments regarding the right to assembly, with rising the sanctions for protest-related offenses, sometimes tenfold, introducing new offenses such as prohibiting face covering during protests, or prohibiting so-called insults to the state officials. These amendments have been harshly criticized both by Venice Commission and ODIHR for incompatibility with international standards on assembly and expression. However, state continues to actively weaponize them against people participating in the protests. There also have been a very recent legislative developments on amendments to the law on broadcasting, introducing this kind of funding restrictions for the medias, restricting them from getting funding from foreign sources, but also introducing a certain kind of content regulations under the guise of fairness and impartiality. These vague restrictions are quite similar to the ones discussed in ATV Hungary case. However, state has already started to use them against Georgian broadcasters. Also, very recently, couple of days ago, government has introduced yet another amendments to the law on expression, changing the standard for defamation cases, which will make media and other actors more vulnerable to the SLAPP lawsuits and defamation cases, and also restricting media work inside courtrooms and in the yard of the courts. These proposed amendments have been criticized by Ombudsperson of Georgia as well, but just today, as they are holding the first committee hearing of these legislative proposals, I was reading in real time the new kind of legislative initiatives that were coming up, even worsening this one. For example, instead of judges, they are trying to give the authority to close the court hearings to for the media to the High Council of Justice, which is even more politicized body within the judiciary. And in the situation where there are up to 60 people criminally detained under the protest-related criminal offenses, and when there are political leaders of the opposition being imprisoned day by day, And when people like Zia Maglobeli, prominent Georgian journalist, remains under politically motivated charges, this kind of restriction on open justice principle and this restriction on media work is really concerning. Another target of this legislative crackdown has been, of course, civil society. Apart from the foreign agents law that I previously mentioned, they have also introduced restriction on foreign grants for Georgian NGOs. They have also introduced a new foreign agents legislation which entails criminal sanctions for non-compliance, up to 5 years imprisonment, which also entails the stigmatizing label of foreign agent. The state has already been using some of these pieces of legislation to require quite extensive data from civil society organizations, such as even personal information of their beneficiaries, which is oftentimes quite sensitive, as Georgian civil societies are actively working with victims of state violence, victims of domestic violence, and this also has a very strong chilling effect on not only on the civil society but on the general public as well. Is their perception of civil society. I think it is also important, this context, this general kind of departure from the human rights standards, from the ECtHR case law, is important to be seen in the context of what it means for the future of Georgia's engagement with the convention mechanisms, with the civil society's engagement, because civil society in Georgia has long been instrumental in ECtHR strategic litigation, in implementing ECtHR decisions. In the near future, I don't think if this path, if this escalating crackdown continues, there might not be anyone left to participate meaningfully the same way that we did before. But even to somehow engage at all, I think that is a really real threat that we are facing. And it is also important to realize that the situation once described in Eco Defense case, that we all agree that was a bit too late for Russian civil society, and described in Kobalia case, these are no longer kind of possibility or kind of prospects in Georgian context. I think this is an existing imminent reality. We are already in a state of that level of ongoing repression under the consolidated authoritarian power, and I think it is, since this consolidation is still quite new in Georgia, I think it is important to continue the scrutiny for GD, Georgian Dream, and for what's going on in Georgia. And I think it's also very important, and I thank EIN for this, to keep this perspective in this discussion about freedom of expression, how the systemic repression, how the violation of other rights, and how this methodic kind of crackdown on human rights plays into this machinery of anti-freedom of expression, anti-human rights policy of an authoritative power. And I won't kind of stretch my speech any longer for the time restrictions, and I'm open for your questions.
Thank you very much, Tamás. Indeed, one indication about the worsening, the deterioration of the problem is the link with other violations. So both us and the Committee of Ministers at Council of Europe level start seeing different types of violations as interlinked. We recently had an advocacy success in the sense that we managed to convince, with the assistance of Georgian colleagues, that what is happening at Tsintabadze, which is excessive violence from police authorities case, links with Article 11 problems, because this type of violence is weaponized to repress and limit the peaceful assembly of all those actors that fight for democratic principles. In the same way that the authorities are trying to to engage and to unfold this methodic crackdown, as you very grimly illustrated, the institutions are trying to catch up, at least. The effort is to convey the message as such to the institutions from our side, from civil society side. The question is how fast the institutions can catch it and how decisively they can do something about it, because time is of essence here. You mentioned that this is a quite new situation, and it begs the question of whether it is mendable still. I want to believe it is mendable. We have not lost Georgia yet in the way that we can lose it still, and it is a matter of who runs faster at this situation, who will outrun the other. The authorities down the path of regression and rollback of democratic institutions and the rule of law, or the institutions trying to prevent that from happening. It is a litmus test also for the convention and the implementation mechanism, which always comes to mind, especially after having had the Russian example. Is the convention mechanism, together with the Council of Europe machinery and in synergies with other regional institutions, capable of stalling down, if not reversing that situation? To be seen and to be answered, and I'm sure we will have great discussions on this. To close the presentations on this panel, we have left for the end the situation in Hungary, and it has been a deliberate decision, another jurisdiction Europe made, so it's closer to our neighborhood compared to other jurisdictions, and it is also an EU jurisdiction, which places the discussion at a different level, but it is one of the jurisdictions where this challenge to the democratic principles and the rule of law is evident. The effort is there. The results of the effort are also there to a certain extent. We might be in a position to have some different answers because we're talking about the jurisdiction within the EU. The question is this is it working? Freedom of expression is big in Hungary. The problem as regards freedom of expression is big in Hungary. It is demonstrated by the extraordinary number for a European jurisdiction of different leading cases dealing with this problem. The colleagues in the Hungarian Helsinki Committee and the HCLU, the Civil Liberties Union in Hungary, have been dealing with those matters very, very closely. They have been, both associations, very close and valued collaborators in this project. They have achieved some of the biggest results and input, and we have our colleagues to discuss these matters with us today. So we have with us Anna Gelencher, legal officer from the Hungarian Helsinki Committee, and Lena Percel, legal officer from the Political Freedoms Program in Hungary. I think I'm reading your CV, rather, Lena, when I say that you are a legal officer. No, it's still Anna. You're a legal officer on the rule of law team at the Hungarian Helsinki Committee, where you currently coordinate the Horizon Europe research project focusing on dissensus surrounding liberal democracies. You hold a degree in law in 2022 and sociology in 2020. And before joining the Hungarian Helsinki Committee, you worked at a law firm focusing on constitutional complaints and human rights litigation, including cases before the European Court of Human Rights. You also contributed to a labor migration-related project at an international organization. I'm looking for your CV, Lena. Do we have it? Yes, we have it. Yeah, it was on a different page. So, Lena, you are a legal officer in the public participation program at the Hungarian Civil Liberties Union, where you focus on freedom of speech and the legal challenges journalists face. Your work includes defending public interest journalism from SLAPS. You also serve as the executive director at the European subsidiary of a California-based EdTech startup, which aims to help students pursue project-based research. You will jointly present to us the overall situation in Hungary, which has different aspects, and we will leave one aspect for a different discussion concerning the free speech of judges. But for all the rest, the floor is yours.
Thank you so much for the introduction, and thank you for having us. It's a pleasure to be here. So as you mentioned, the freedom of expression problem in Hungary is big, and that's correct. In the last 15 years of the two-third majority of the ruling party, Fidesz, in the parliament has led to a very significant erosion of the rule of law. It's not a side effect, it's a very deliberate erosion. To illustrate the constraints on freedom of expression, sorry, I forgot to move forward. So I just wanted to gather the cases that we see at the Hungarian Civil Liberties Union in our work. So we see a lot of increasingly strict freedom of information regulations, physical barriers, obstructing the work of the press, journalists, SLAPS as surveillance targeting, state surveillance targeting journalists, and also a very big issue, the centralized nature of the public media, which is increasingly absorbing previously independent publishers. And also a recent, development you might have heard is the draft law, which was currently put on hold, but it was based on the good, bad practices that we've heard in the previous panels, or this panel, which is a foreign agent law, so to say. And it has been put on hold, but we don't know when it's going to be dropped down on civil society and the media organizations, especially because we're seeing upcoming elections, 2026 next year. We're expecting even worse measures from the government. So some of the most pressing cases have been brought in front of, before the ECtHR by the civil society organizations working in Hungary, but it's very obvious that the implementation is very weak. There's no proper enforcement system in place. We know that Hungary is not alone in this, but what's to be mentioned is that Hungary's reluctance is very deliberate. So just a little bit of data that shows how the Hungarian government is at the forefront of sabotaging the implementation of ECtHR judgments. Hungary has the highest rate of non-compliance within the EU member states. 76% of the judgments made, that is 45 judgments. It's very obvious that the reasons behind this, like the failure to do so, is not due to administrative delay or the lack of capacity, but the lack of political will. So this is one of the biggest obstacles that Hungary sees here. Just like to illustrate the deliberacy, although this is a case from the EU court, the Court of the European Union, the government is willing to pay 1 million euros per day rather than to comply with a judgment that's against migrant pushbacks. This is not an Article 10 concern, but I thought it was important to mention how the narrative says it's still better than letting the migrants in. And this money is put aside in the budget so that Hungary is able to pay for it. The second big obstacle that I want to present is the lack of independent internal institutions that can hold the state accountable. What we see is the only solution is if the ruling party has to pay the political price. But for this, we would need the society to react, but the society remains largely indifferent. I forgot to. Right, yeah. Sorry about that. So it remains largely indifferent, and the reason for this largely is that the state-owned public media is dominating discourse on every topic and every issue that's going on in Hungary, with highly paid influencers and absorbing independent media. So it's really hard to reach any progress. But we can highlight some progress, and that is thanks to the last 2 years that we cooperated with the EIN, with the coordination of EIN. We're going to mention 4 cases briefly with my colleague from the Helsinki Committee, Anna. We won't really go into detail because our goal here is to give an overview and to present the small steps that we can account as progress. So I'll give it to Anna.
Thank you. So previously we just heard about how the judgments of the European Court of Human Rights are routinely ignored in Hungary. And this is not just due to weak enforcement procedures, but also as a result of deliberate political will. So now I would like to highlight 2 cases and to show you what does it look like on the ground from the Hungarian side. Both of the cases I will present. One of is Kennedy versus Hungary, and the other one is Helsinki Committee versus Hungary. And both of them concern something very basic, what public authorities do, and the right to know what they are actually doing with their power. So in the Kennedy case, Mr. Zoltan Kennedy, who was a historian, he requested data from the secret services for his academic research. This request was actually denied. So Mr. Zoltan Kennedy initiated a lawsuit in Hungary. And even in domestic courts in Hungary, in both levels, said that secret services has to disclose the data. But the secret service decided not to comply with this decision. So there was no other choice than to bring this case to Strasbourg court. And actually in 2009, the Court of Human Rights ruled in the favor of Mr. Zoltan Kennedy. It happened in 2009, and still, like more than a decade later, nothing has really changed. There was no implementation. So what also the Hungarian Helsinki Committee has done in 2021 is that we created and conducted a research about the non-compliance with both international and domestic court judgment. And we were focusing on specifically freedom of information requests. And we found that the Kennedy case was not an isolated accident. It was a result of a systematic issue. And also, I won't give you further details how the Hungarian system looks like in terms of enforcement procedure, but let's just say that this is really bureaucratic, really slow, and the applicant has to bear the burdens. So we use this data and these results based on our research, and we collaborated with also the Civil Liberties Union, and we started to submit Rule 9 communication in 2022 and in 2024. And this actually had a result, because previously, in 2024, this case, the Kennedy case, was placed under enhanced supervision. So this was also acknowledged that this is not an isolated accident, but this is a systematic issue. And now I would like to turn to another case, which raises more dilemma, maybe. And this is the Helsinki Committee versus Hungary case. In this case, we requested data from the police, and we were curious about how the police actually appoints ex officio legal aid lawyers in Hungary, because we had this concern that some lawyers actually receive outside number of requests, which actually hinders and undermine the right for defense. Some of the police actually disclosed the data, while some did not. And the case ended in Curia, and the Curia ruled that actually our request had some question which includes personal data, so the police doesn't have to disclose anything. So after that, we brought the case to Strasbourg. And in 2016, it was ruled in a Grand Chamber level that freedom of information request falls within the scope of Article 10. And this was the first time when at the Grand Chamber level this was stated. So I believe that this is a landmark case, but not just for Hungary, but also for all Council of Europe member states. So this happened in 2016. A couple of years later, the procedural code for criminal proceeding has changed in Hungary, moving the power to appoint these ex officio lawyers from the police to bar associations. And this sounds, for the first sight, a very good result, but they left one exception, that the police can appoint substitute lawyers. And at the Helsinki committee, we had anecdotal evidence that the police is abusing this power once again. So a couple of months ago, we requested data from the police again, asking about the appointment of substitute lawyers, and the police denied this request. And an interesting fact that they were not saying that the data we asked was not public data. They were not saying that they don't have the data. They simply said that they don't have the data in the format we asked for. So we can see that this is rather a technical argument, still has the same effect. So the dilemma arises whether the 2016 judgment is actually implemented or it was reinterpreted into irrelevance. I believe that both of the cases I highlighted shows what happens when institutional decisions, both on domestic court and international courts, actually collide with political will.
Thank you. I will just add two more cases briefly, and then I'll talk a little bit about what we can do as civil society organizations. So the case that the ACLU brought before the ECtHR was Surovec against Hungary. He's a Hungarian journalist, and he intended to report on living conditions in a refugee camp during the 2015 refugee crisis in Hungary. His request was rejected, and there was no legal remedy for that. It was rejected on citing privacy and security reasons. The ECtHR found a violation of Article 10, as it stated that gathering information is a protected part of journalistic work. But this hasn't been implemented since. The judgment became final in 2020. To give a little context, during the refugee crisis, it was the government that dominated the discourse. It used the refugee crisis for political purposes, and because of the government's control on the narrative, there was little to no desire for independent information from the society. And in this context, we can understand more how these little, not really little, but individual cases support the big goal that the government is leading. It's increasingly relevant, this case, because journalists are increasingly barred from entering certain places in Hungary. For example, government press conferences, or we can talk about the recent eviction case of Mérce, where the journalist was not let into the building where an eviction was taking place. And so it's very, very important, and thanks to EIN, we could file a Rule 9 submission, and we could prevent the Committee of Ministers from closing the case. So this is one thing we can account for as an important step. And the other case that I would want to talk about is the ETV-ZRT versus Hungary case. In 2012, a television company, ATV, referred to the political party Jobbik as the far-right party. And for this, the television company faced penalties from the media authority, because the authority explained that the phrase constituted a value judgment rather than a factual statement, and that publishers were prohibited from expressing opinions in order to preserve unbiased political reporting. Although the ECtHR ruled the violation of Article 10, there has been no progress in this, and the action plan of the Hungarian government is not sufficient. It did not amend the Media Act, which enabled this censorship. And again, a little success. We blocked the closure of the case through a Rule 9 submission filed by the ACLU and coordinated by the EIN. So I'll briefly, it's mainly a question because I can't provide solutions here because as we see, the biggest issue is the lack of political will. So without government change, nothing or not much is going to change regarding the implementation of ECtHR judgments. But what we can do as CSOs, we can bring cases into spotlight, bring them to a European level, fostering international cooperation like we did in the last 2 years, which was very impactful, and yes, we need to enable and spark debate, and what we also work really hard on at the ACLU is raising awareness on these issues. As I said before, it's very hard as government propaganda is dominating discourse, but in the end, we see that it's the only thing that can lead to significant change and development is if the government has to pay the political price for its non-compliance. So, yes, it's the state of freedom of expression is not in complete neglect in Hungary, but it's definitely in decline. And our role here is to not let really extreme cases happen in Hungary. So thank you so much for letting us be here.
It's not about letting you, it's really about creating the space for you to be here. We need you here. We need to have you here for these discussions. Thank you very much. We deliberately also let Hungary for the end to end on a more positive note, although from your national perspective things do not look positive, but if we put them in perspective and compare to what is happening to other countries, I think there is still hope and advocacy is still working. I know you don't take it as a win, what happened with the postponement of the vote on this repressive law on foreign agents, but it is a certain impact. It demonstrated impact of this collective, unprecedented for our standards, response to civil society also, and to IGOs as well, not just civil society, also institutions reacted very strongly, and there was impact. So let's pattern those results rather. I very quickly open the floor for questions. We have very limited time, but we can still take a couple of questions.
Thank you for the presentations. I want to address my question to İdil because it concerns Turkey. You said that it's not about laws, but judiciary that, if I understood you right, that for some reason applies laws wrongfully, and judiciary that creates practice of violating human rights. But how's the system, how does it work then? What is the problem? Is it because we elect judges loyal to the political regime, or is executive branch that affect them? What is the problem? And do you think that European Court of Human Rights or Council of Europe should give more attention to that? Because this is what is not given enough attention. I mean, in the whole in the whole practice of the European Court of Human Rights, it raises a huge number of questions. For example, the question of should we exhaust domestic remedies, for example? Just one of them. This is my question. Thank you.
Can I also have a quick question to Anna and Elena. As you know, like Poland was in a very similar situation as some time ago as Hungary is now, and my question is, how do you deal with addressing all of the issues you have back home? Meaning that, for the context, some time ago I met Beatrix Visi. I don't know if I pronounced her name correctly, and thank you. And she was in Brussels, and we talked about SLAPs, and she was saying that you, for example, sued. We're planning to sue the government for the freedom of information, access to information case relating to the implementation of the anti-SLAP directive. And what I'm wondering is, like, if you have so many like basic problems with execution of judgments, with threats against journalists and stuff like that, do you still try to tackle more advanced issues such as implementation of the anti-SLAP directive, or is this just something you try to leave on the side because it's likely that nothing is going to happen in those aspects in the future? Thank you.
Thank you. Sergei Dikman, Council of Europe. I work for the implementation, National Human Rights Implementation Department. So my comment will be now in my personal capacity. I have to stress that. It would rather concern the three first speakers who spoke about Turkey, Georgia, and Azerbaijan. And Idil, you mentioned that you questioned whether a stronger pressure should be put on Turkish government, and whether cooperation, which is now blooming, although it's actually withering in the last few years, should be completely shut down in order to push a country for more compliance. So for me, it is an open question, in fact, because we see three situations. You know that the Committee of Ministers decided to freeze any cooperation with Georgia and Azerbaijan, and countries which were giving money for this cooperation, they explicitly said that they do not want their funds to be spent on any efforts, on any activities with the authorities. And in particular, it was a case in Georgia, they said that they would rather give money to civil society organizations, but then the Georgian officials, of course, they would not want this. And at the same time, in case of Georgia, the government repeatedly asks for continued cooperation. So they want the action plan of the Council of Europe for Georgia, which exists, which is in force, to be implemented. On the other hand, Azerbaijan does not want this cooperation, so they are okay with the freeze of cooperation. And then you have Turkey, which has more or less active cooperation, and as you said, they measure how beneficial it is for them. So the question is whether actually having an active cooperation or having no cooperation has any impact on the country being compliant with the court's judgments. In my view, this is maybe not the first factor which contributes to the compliance. And you know, the Council of Europe's possibilities of enforcement of judgments are pretty much limited. Maybe it is a bit, because as such the Council of Europe's weight and the benefits to the states are sometimes put into question, so why we should be compliant. So for countries which are have the candidate status for the EU, that could be some additional benefit. But I think in case of Turkey, Turkey has long given up on EU membership. Maybe I'm wrong, but maybe you have a different perspective. So it's kind of it's rather a reflection from the side of cooperation, because we do interact with authorities. We see that in Turkey we had many really good projects implemented with the Constitutional Court, for example, which is delivering judgments with reference to the case law of the European Court. Another issue that they are not implemented by the very Turkish authorities. So I would rather be personally skeptical that shutting down any cooperation is contributing to the improvement of the situation. Thank you.
Yes, we need to wrap up very fast, so can you please give your answers succinctly, 1 minute each, because the next speakers have some time constraints. Thank you.
So I'll start with the last question. I think maybe I was misunderstood, but I'm not calling for like a complete removal of Turkey from the system or a complete lack of cooperation. But as you said, Turkey is an EU candidate country, and it is debatable to what extent Turkey has given up on that hope, but still it participates actively in that process and responds to some of the criticism from the EU. So I think we need to see more of that also from the EU side. If the Council of Europe is not such a strong mechanism for implementation, then we have the EU member states. We have incredible economic ties with most of them. And I'm also for cooperation. I think there's definitely room for dialogue, but there has to be more pressure. And just like a brief example is the refugee deal we had with the EU, which was, I think, one of the things that pushed forward the kind of problems that we have today. So that was in 2015-16. Fast forward 10 years, we have a more most of the problems are even more ingrained, etc. So just like a little example. And on your question, again, it's a long process, which we can discuss for a really long time, but we had constitutional amendments in 2010 and then in 2017, which changed the Supreme Council of Judges and Prosecutors, so which gave the executive most of the authority to appoint members of this council, which then appoint judges and prosecutors. So we have, executive's control over judiciary. So we see sometimes that even judges are penalized. They're moved elsewhere if they they're removed from their positions if they decide on cases in a rather freedom-oriented manner. But at the same time, even at the interview process, you don't see, prosecutors and judges who are, not even anti-government, but who are perhaps more critical of their policies. They don't even make it through the interview process. So we have a judiciary that has no will to implement judgments in a way that is, protective of fundamental rights. So I think that's one of the key issues, and we need to really change the whole system to be able to see positive effects on that. And also just one thing to mention, after the coup attempt in 2016, it was the Constitutional Court itself that dismissed 2 of its own members. So you see, like it seeps through the cracks, and it's a very entrenched problem that we see. Yeah.
I would also comment about Georgia's kind of openness to the cooperation with EU or Council of Europe. I think what Georgian government wants right now is to continue the suppression and crackdown, but to also have certain kind of this facade of normalcy with international community. I think what would they enjoy very much is what they're trying to do in Georgia is to sell this narrative that nothing special is happening in Georgia, and on the international level their actions are and will be accepted as normal because the same thing is going on in every democratic country. And I think if this false narrative could very much be supported with this kind of cooperation efforts, if there will be any by EU or other international actors. I think at this point, of course, no one's, in Georgian context at least, no one's talking about shutting out of Georgia from any international forum. But at this point where this kind of authoritarian consolidation is quite new. There is still people in Georgia protesting to this. There is still civil society in Georgia, and there's still some political friction in Georgia, even though they are under escalated this pressure. It is important to also international community show very clearly where their support lies. I think the PACE suspending credentials for Georgian representatives was a good example of that. Yeah, because what would GD want to do now is to sell this picture of normalcy, cooperation, and this kind of business as usual, which I don't think will be case for Georgia for quite some time, until, if this regime continues.
Thank you. I will also just briefly address the responses from civil society sides and the tools and practices we have. And just really generally, I think it's important for civil society working in these problematic countries, let's say, that we not just give responses to the actual actions of the Hungarian state or any state, but we have to have a strategy which is our own, and it's not reflecting always, but also acts. And I think that's one of the biggest challenges we face, not just to react, but have a strategy. And we have a saying at the Helsinki Committee when we plan a strategy to plan it for 70%, leaving 30% to react. So always have teams which react like straight away, but leave the others to work on the issues we want to address. And the other thing, especially regarding the non-implementation of the judgments, I believe that it's important that we keep the topic and we communicate not just on advocacy level, but also towards society. But also we have to be realistic that it has a limit, because especially when it comes to non-implementation, there is a need for political will and legal reforms, and we can do whatever we can with advocating, documenting, representing clients, but there is a limit for that, but still we have to keep these issues on the agenda.
So coming back to this question of cooperation projects between the Council of Europe and Azerbaijan, in my case, I think my answer is very brief. I think it's all about the effectiveness of those projects. It's about assessing the effectiveness, given the fact that the government clearly resists or refuses to comply with the judgments, to engage with the Council of Europe and all that. And perhaps we should then look into supporting civil society and using some of those public funds of the taxpayers of the Council of Europe to direct it to the actors that are willing generally to engage and certainly are in need of the support. So it's really, rather than yes or no, it's about how effective that is, I would say.
Thank you. For your question, Susanna, yes, it is a challenge to tackle all issues, and it's probably not a way to do it. So that's, as Anna mentioned, we also have we're very strategic on what we focus on, and it's really hard to balance when to and where to put the effort. Something that's a bigger issue, local ones, or that needs a lot of effort in order to address it. We are focusing on such issues, and it's all about where we direct our efforts. But we really aim to work on that. But just one thing that I want to add is that we do see that it's very unlikely that we get somewhere because the state does not engage with us. Especially the case you mentioned on the freedom of information request regarding the anti-slut directive, there's no way basically on going that way. So what also Anna mentioned, we're focusing a lot on society and trying to raise awareness so that society says no to what's happening in Hungary. Thank you.
I just realized I forgot to answer the part on exhausting domestic remedies. This is something that civil society is pushing forward to an extent, not exhausting the Constitutional Court as a remedy, but of course the European Court is extremely reluctant to accept that, and there has been cases that were just rejected for non-exhaustion, so it's not a risk that civil society or lawyers are willing to take, but this is an ongoing debate, and the Constitutional Court itself also gives certain positive judgments so as to protect its reputation, to give itself legitimacy while giving, completely misplaced non-violation judgments when it should have found a violation. So just to mention that this is a matter as well.
Thank you very much to all. The matter cannot be exhausted, of course, but your very important insights have helped us keep up these questions on our agendas, continue exchanging among us on these very important matters, and continue bringing our international support to the extent that we can to the very important role you play in your national jurisdictions. We are here to continue the discussions. I also have a couple of questions for you, but they also fit well with tomorrow's discussion, so we will rather discuss them tomorrow. Now, because we need to accommodate the speakers of the next panel that are intervening online, and because we are still, I think we hold some strength from the lunch break, we will rather leave the coffee break for after the next discussion, and we will just take 2 minutes to change the guard here on the stage, and Camilla and Fede, we're with you in 2 minutes online. Thank you.